Welcome back to the Elder Law and Guardianship Training video series for attorneys. This third video in the series focuses on alternatives to guardianship. Act 61 of 2023 requires that guardianship petitions explain which less restrictive alternatives were considered or tried, and why they are not available or sufficient to meet the needs of the alleged incapacitated person. Courts are required to determine whether there are any appropriate, less restrictive alternatives to guardianship available, and, if not, whether a limited guardianship will meet the needs of the person in lieu of a plenary guardianship. While this process takes time, it is time worth taking to ensure that an alleged incapacitated person has every opportunity to retain their rights to the extent possible. Avery has now been working at Miller, Jordan & Wise for almost 6 months. Charlie has asked him to prepare a short lecture on alternatives to guardianship as a resource to train their own staff and attorneys.
Okay, Mr. Green, present it to me like I know nothing about the topic.
Even though you gave me over 100 pages of research documents?
Yes. Forget about who gave you those. Go for it.
Thanks for your time, friends. I'm going to be telling you all briefly about alternatives to guardianship. It might be helpful to think about alternatives to guardianship in a few different categories. Some of them require a document, signed by the person at a time when he or she had the capacity to sign the document. In some of these documents, the person designates a specific person or people to act on their behalf. In other documents, the person sets forth their own wishes that they direct should be followed. Other alternatives are more informal, such as setting up automated electronic bill paying, or setting up a service such as Meals on Wheels, or having a trusted friend or family member set out medications in a daily pill reminder box. Some of these alternatives require a person to participate in planning and signing documents before they may be needed. Other alternatives to guardianship can be implemented even if the person has become incapacitated and can no longer sign a power of attorney or other document. A financial power of attorney, or POA for short, allows a person to appoint a trusted individual, referred to as an agent, to help with accounting, bill paying, and other short and long-term financial tasks immediately, or in the event the individual becomes incapable of managing his or her own finances. The POA will outline the exact powers and responsibilities of the agent and when the agent is authorized to act on the person's behalf. Worth noting, a financial power of attorney, like other advanced planning documents, must be executed before the person loses capacity. Advanced directives for healthcare include living wills, healthcare power of attorney, and physician orders for life-sustaining treatment, or POLSTs. A living will is a legal document that informs doctors about your preferred treatment options regarding life-saving or prolonging treatment decisions if you become unable to make or communicate your decisions. Similar to financial POA, a healthcare POA grants the agent power to make healthcare decisions on behalf of the person. This can include specifying the treatment, including routine care, admissions to facilities, end-of-life care, and more. A physician order for life-sustaining treatment, a POLST, is a document created by a doctor and patient when that patient has a terminal illness. The POLST details the person's end-of-life care preferences. Additional advanced directives focus on mental health needs. Both a mental health advance directive and a mental health power of attorney, whether utilized in combination or separately, can appoint an agent to act on the person's behalf and provide specific guidance on a person's preferred treatment, medication, and providers during a mental health crisis. Healthcare representatives have authority granted by the Healthcare Agents and Representatives Act. If the person's doctor determines the person does not have the capacity to make their own medical decisions and they do not have a guardian or healthcare power of attorney, a healthcare representative can make certain decisions on their behalf. This is a good example of an alternative to guardianship that does not require the person to sign a document or to have capacity to select the person to be their representative. When determining who is eligible to be a healthcare representative, priority is given first to spouses, then to adult children, and then to other family members. If no family members are available, other adults knowledgeable about the person's preferences and values are also eligible. However, note that the individual's primary care doctor and anyone who works for a healthcare organization involved in their direct care are ineligible. Social Security benefits can be managed by a representative or rep payee. The rep payee, much like a guardian of the estate, must manage expenses strictly, spend Social Security income only to the direct benefit of the Social Security recipient, and file a detailed annual report with the Social Security Administration. Similar authority and requirements are in place for a fiduciary of someone with Veterans Administration or VA benefits. VA fiduciaries must undergo an investigation by the VA prior to approval. It is important to note if a guardian is appointed, a separate rep payee or VA fiduciary could be appointed by the federal agencies. For example, a guardian of a person living in a nursing home may elect to have the nursing home named as the rep payee to help facilitate payments. It is also worth noting, though, that family members or court-appointed guardians are a preferred choice for rep payees according to Social Security Administration policies. When assisting a person who receives Social Security benefits, whether as a rep payee or in another capacity such as an agent under a power of attorney, it is important to understand and plan for any changes to Social Security benefits and any income limitations which could occur if the person is receiving benefits but below normal retirement age, or if the person is receiving Supplemental Security Income or SSI benefits. Certain scenarios about a person's finances or past can affect their entitlement to SSI benefits, so it's helpful for counsel to be aware of the complex do's and don'ts around these situations. Limited guardianships are guardianships that allow the alleged incapacitated person to retain some of their rights and decision-making authority. The judge will assign specific decision-making authority and responsibilities to the guardian. The guardian only has the authority stated in the limited guardianship order. The incapacitated person retains all other rights and decision-making authority not specifically awarded to the guardian. The attorney for the alleged incapacitated person and the attorney for the petitioner should discuss the specific provisions that should be included in a limited guardianship order in advance of the hearing. Limited guardianship orders must be customized to the specific needs and abilities of the alleged incapacitated person. Other financial alternatives to guardianship include PA-able accounts, special needs trusts, joint bank accounts, money management and bill pay services, and even viewing-only account access permissions. PA-able accounts allow Pennsylvanians with a disability to set aside savings money for education, housing, transportation, and more. There are specific requirements to qualify for PA-able accounts and special needs trusts, so keep in mind that these options may not work for everyone. To enroll in PA-able, a person must have a qualifying disability that started prior to age 26, demonstrated by either entitlement to SSI or SSDI benefits based on blindness or disability, or self-certification of a disability. Special needs trusts can help preserve a person's eligibility for Medicaid, SSI, and other benefits, and allow other saved and invested dollars to be utilized for a wider range of supports, such as health aids and equipment, educational, entertainment, media, clothing, and vacation expenses, healthcare and insurance, home-related items or repairs, and more. Joint bank accounts can actually serve as an alternative to guardianship as well. Sometimes they are all the financial oversight a person needs. However, it is always wise to be aware of the risk of a joint bank account, as both the original account holder and the added account holder have equal access to manage and spend the funds in the account, which can lead to issues if the joint account holders cannot be trusted to act ethically. Banks may also allow account holders to grant someone viewing-only access to their account, which can be helpful as well, as it provides a trustworthy family member or friend a way to monitor finances on behalf of a loved one without having either the risk of spending authority or the burden of reporting requirements. Supported decision-making involved both a person seeking support, who is ultimately also the decision-maker, and one or more friends or family members who are offering to assist them. Supporters identified can be an individual or team of helpful friends and family members that the person trusts. The supporters collaborate with the decision-maker to provide a conscientious network of assistance, but the decision maker retains all rights and decision-making power. Supported decision-making arrangements can be formally documented or informally agreed to. They make it much easier for family members and friends to help each other out in times of need. Pennsylvania has not formally adopted a statute expressly recognizing supported decision-making agreements, but formal or informal supported decision-making agreements can be established with or without judicial approval and qualify as less restrictive alternatives to guardianship under Pennsylvania's guardianship statute. Judges are also able to recognize and approve supported decision-making arrangements as a reasonable alternative to guardianship. It sounds simple, almost too simple to be believed, but it's true. Sometimes the answer and support a person needs is just a phone call away. 211 can connect Pennsylvanians to support resources like in-home care, transportation, assisted technology, housing, and more. 988 connects the caller to a suicide and crisis lifeline that can mobilize mental health support teams for therapeutic interventions and more. Adult Protective Services and Older Adult Protective Services can be called to assess whether a person is being exploited or abused and can provide necessary services that can protect the person without necessarily requesting that guardianship be appointed. There are so many alternatives to guardianship available. For attorneys and judges to be well versed in the ways they work and how to effectively implement and monitor them allows more and more Pennsylvanians to receive the support they need while also retaining their rights. Thank you.
Okay, that was concise and informative. Nice job.
What do you think? Too simple, too direct?
I don't think so. Explaining the concept with directness and clarity is helpful, partly because there are so many alternatives. You could present for an hour on power of attorney alone or other alternatives, but that's not what this presentation is for. Employing alternatives often comes down to the judge and attorneys being willing to work together with creativity and flexibility, depending, of course, on the client's level of capacity. Additionally, alternatives must also be consistent with the client's desires and best interests. Every case is unique, every client is unique, and everyone needs a unique solution. You're giving people a pretty broad menu of options here. Wait until they realize they can customize solutions even beyond that long list.
Charlie touches on an important point here, which is that courts have a great deal of flexibility and authority when it comes to approving alternatives to guardianship. We're going to shift now to our expert interviews to get a wide range of additional perspectives on alternatives to guardianship.
Since the legislature passed Act 61, it's become increasingly important to judges that all of the parties to the proceeding be prepared to discuss possible alternatives to guardianship, to look for ways that the individual's needs can be met by people in their community, people in their family, and to consider whether a guardianship really is needed in this case or whether there might be a more effective less restrictive alternative to guardianship. We do rely, though, on counsel, both the petitioner's counsel and counsel for the alleged incapacitated person, to prepare even before the court hearing. Remembering that the judge is only hearing this for the first time on the day of the hearing, so we really need to know that the parties have discussed this with each other, have prepared and have considered vigorously what the options might be, and can present to the court options in addition to guardianship that might be preferable to guardianship.
I make use of some checklists that help me throughout the course of a hearing to be reminded of what I should be receiving in the form of information about the person's mental health, physical status, diagnoses, what their needs are going forward, be it medication or treatments or therapy or surgeries. Let's talk about their living environment. Is it going to be the same or changing, maybe going forward? The Keck School of Medicine out of the University of Southern California did a pilot program a few years ago with judges around the country in which they developed a checklist, and I think it's appropriate just to acknowledge that I was part of that group of judges nationwide, so I had the benefit of that checklist, and I use it to this day. And for me then, it allows and it prompts me to ask a lot more questions about options and to be reminded of where, we may have fallen short in knowing about the person. Because we do talk about their life experiences, we talk about who is able to give them care and who isn't. We can, again, take the time to ask a lot of questions. And if I think that an attorney has fallen short for the petitioner or for the alleged incapacitated person, then I at least have my own list to make sure I'm reminded of what to ask. And that, I think, frequently then leads to better outcomes.
In the conversations with clients, many of them already have alternatives to guardianship in place. They may not have realized that they have. So, for example, they may have a family member who helps them pay their bills or takes them to doctor's appointments, takes them grocery shopping or to the bank. Those supporters are part of an alternative to guardianship plan, people who can be around and available to you as you start to decline, to take care of you, fill in gaps where you're not able to take care of yourself. Formally, we draft financial powers of attorney to give legal authority to those people who are already making financial decisions or helping the client to make financial decisions. And we draft healthcare powers of attorney, which also gives legal authority to somebody who may already be coming with you to the doctor and interpreting what the doctor says so you understand. We're empowering them through these legal documents to have that authority to speak on our client's behalf when the client isn't able to. And the client is someone who, when they have capacity, can choose whomever they want, the person that they trust the most, the person that they think will be best positioned to help them when they decline. So really the power is in the client's hands to decide who it is they want to care for them, who the people are in their lives that they want to be around when they're no longer able to make decisions for themselves.
But I think the most useful alternative that we explain to people is the availability of healthcare representatives under Act 162. And we will explain to people that certain family members or others in a order of priority can make medical decisions for a person who does not have capacity, and we will explain to them how that works. And very commonly, people will say, "Oh, I will go away and try that," and I will say, "Come back if that doesn't work." And we do not tend to see those people again. And so those are alternatives that work in many cases to enable people to handle decision making for their loved ones, whether it be family or close friends.
One thing I hope that lawyers will begin to move away from is there are some lawyers who think that when they're asked to, is there any alternative to guardianship, they may say, well, this person can't sign a power of attorney, and that's it. That's all we're willing to consider. When really what you need to do is take stock of the whole situation, find out, does this person have any income? Do they have any assets? Is there a need for a power of attorney? Perhaps they only have Social Security income and maybe someone is already the representative payee. If that's the case, why are you petitioning for guardianship at all? They don't need a financial agent or a financial guardian. So the inquiry has to just go further than stopping at, is there a power of attorney and can this person sign a power of attorney? And the same thing goes in the healthcare area. Whatever the decisions are, it requires some exploration of the person's home life, what their supports are, how they make decisions, and what are the things that they can handle or that with supports they can handle, and how can we make sure they have those supports?
Obviously, your arguments should be grounded in the evidence and the facts as they are presented. I appreciate when attorneys are asking tough questions about alternatives to guardianship of the petitioner or suggesting to the judge that there are alternatives. At the same time, though, I think that it is not, wise to make suggestions that, frankly, are going to be potentially harmful to the individual. If we're leaving too much to chance, then that means a third party can come in and maybe act in a way that's harmful. So we want to make sure we're resolving that question too. So it's always the idea of what can we do to maximize alternatives to guardianship, but what are we also doing to make sure that we're giving the person all the supports they need? So we don't want to have this idea of I'm going to focus on one form of an alternative to the exclusion of all others. That is going to be, I think, a challenge for a judge then to say, is it that simple? Because none of these cases are ever simple. These cases are very challenging. Each person has their own needs. There will never be a one-size-fits-all solution. So what are we going to do? And I think that counsel needs to be very flexible in the moment. They need to be thinking about it. They need to be really listening. And if they are considering all their other alternatives, they ought to be able to explain to me why each alternative under the statute should or should not be considered, right? Not just a blanket, these are unacceptable and this is the only option. Now, if that only option is nothing because the person is competent and shouldn't even be in court, why don't we start right there? That's the best starting point for me. So.
I'll start with where things may not go well, and like I said before, there's situations where families wait too long, where their loved one, their family member has already started to decline or is experiencing difficulty managing their life. And at that point, the family seeks alternatives to guardianship. When it's too late, there's not much that we can do other than guardianship. We can try and limit it, but guardianship is often a last resort. When things go well, tend to be situations where the client has a support network, they have family and friends who are willing to step up and act on their behalf, and make sure they're cared for, make sure they're not neglected, make sure all their needs are met. And they're willing to listen to the client while the client has capacity and make sure they understand what that client values, what's important to that person, and how they want to be treated and cared.
We really strive to find alternatives to guardianship that work. And I have had occasions when individuals who previously had a guardianship may no longer need a guardianship. I had a great experience with a family recently where their son had had a traumatic brain injury due to a car accident. He had been a college student at the time, and initially there was no question the parents needed a guardianship to start making arrangements for his finances, for his health care, for a myriad of things, for a lawsuit I think that was filed. So they needed a guardianship, and he was virtually non-communicative when the case started. After about 2 years, he had significant improvement due to ongoing treatment and therapy for his brain injury. He was able to return to school. He did have some limitations, but his family and he all thought that he no longer needed guardianship, that with the support of his family, he could resume his studies, live on his own with supports, and they could support him in other ways, but they didn't any longer need to be his court-appointed guardians. So that was a really wonderful story about how things can progress and how we need to be open to changing the status of a guardianship.
I was presented with a petition for a gentleman whose family members realized that a guardianship order that was entered decades ago in a very paternalistic way really wasn't needed. And they appreciated the new emphasis on alternatives to guardianship. And they were individuals who were very, very comfortable with helping their family member. And they do it with happiness and joy, and they really like supporting their family member. So they basically took the time to put safeguards in place such that, and basically all monies were placed in a trust. Doing the analysis, there was just no need for guardianship. And they didn't really see the need to prepare any of the reports. And through the course of a hearing, I was able to fully understand that these individuals, being upstanding caregivers, they didn't need guardianship. And so I was able to terminate the guardianship. And that was a really particularly nice thing to do for that family. I have seen, though, unfortunately, needs for emergency guardianships where there's a great deal of harm. And unfortunately, the person has no one. And it's pretty clear that they are being taken advantage of by someone who, for lack of a better word, is a grifter, and who is seizing the opportunity to obtain housing and money for themselves. And you do need to stop that, and you need to protect the person from themselves, because they are convinced in their mind that this person is the only person that's going to help them because this person shows interest, and it's nothing but a ruse. And those are particularly sad situations, and unfortunately they can turn to be dangerous situations. And in those instances, we have to have law enforcement, sheriff's department, and others, sometimes even in the courtroom, helping us make sure that we're protecting the person. But we understand that in the moment that's very traumatic. So it's not a pleasant situation to be in, but it's a necessary one.
In our next scene, Avery gets perspective from Charlie on how to best navigate some of the more nuanced aspects of alternatives to guardianship.
Your presentation went well this morning.
Thank you. So, on the one hand, I see how the nuts and bolts foundational info in my presentation can be helpful to our staff and attorneys. But on the other hand, I know alternatives to guardianship in the courtroom isn't a one-size-fits-all solution.
The longer you do this, the more you'll start to see how you might want to inform and advise your client about their options. And our job is to advocate for the client's wishes ultimately.
So what's an example from your career that comes to mind that helps illustrate some of the nuanced aspects of this for each client? I'm sure you've experienced this firsthand.
Well, I had a client a few years ago who couldn't drive anymore and had issues around sorting out travel logistics. He couldn't figure out where he needed to go. We actually got him connected with a nonprofit organization that organized free rides for elderly clients. He now gets a weekly ride to the grocery store and rides to medical appointments as needed. It made all the difference for him. Another client had a tight financial situation and wasn't really able to cook for himself. We connected him with Meals on Wheels. It made everything else easier, just taking care of that one challenging task. In both of those cases, the judge asked to speak with counsel before the hearing and was very direct with us. The judge essentially said, it seems as though if we can solve 2 or 3 of these persistent issues, this person might not need a guardianship. We discussed ideas in chambers in order to come up with a least restrictive plan that supported the client's desire for independence. And when I presented my clients with these proposals, they enthusiastically agreed. It didn't seem like those solutions would make such a big difference. But those judges and clients, they thought they might, and they really did.
The possibilities are seemingly endless.
Staying open-minded to unique needs and desires of the client is essential. It's worthwhile to ask for suggestions from family members, the petitioner, and from agencies that provide services in the community. Listening to the client, listening to the judge, staying flexible and creative while always keeping the client's wishes front and center. It's a bit of a delicate dance, but all of those things are so critical for delivering best outcomes.
As you can see, alternatives to guardianship encompass a wide range of possibilities. Creative judges and counsel can help keep Pennsylvanians in need safe, secure, and healthy without taking away their rights in so many cases. Awareness of alternatives to guardianship and a creative willingness to implement them are best practices in guardianship cases. That said, every case is different, and for some people, a guardianship is precisely what they need. And whether it's an alternative to guardianship, limited guardianship, or plenary guardianship that's needed, it's essential for lawyers to be especially mindful of the client's wishes, and for court staff and judges to be vigilant about the incapacitated person's safety, well-being, overall health, and financial soundness. Ideally, both lawyers and court staff can work together for the best outcomes for the alleged incapacitated person. Thank you for watching Part 3 of our video series. In Part 4, we'll take a look at 3 key guardianship topics: limited guardianships, guardians ad litem, and emergency guardianships.